Going to start. Um, Welcome, everyone, to this Customs and Global Trade webinar. Today's topic is the proposed amendments to the Valuation for Duty regulations. This may be one of the most important regulatory changes that I've seen in many years that impact how goods are valued and the amount of duty that is levied on goods when they're imported into Canada. The purpose of this presentation is to provide an outline of the current state of the regulations, the proposed future state through these proposed regulations, and deal with potential options. My takeaway from this is you, as an importer and as service providers, should apply the proposed changes to any business model that currently exists, assess their likely impact, and review options and make adjustments when possible. So my name is Dan Kisselback. I'm a partner at Miller Thomson in Vancouver, and we're happy to host you today together with Dave Pentland of Carson International. Of course, Miller Thomson is a business law firm across the country with 10 different offices in 5 provinces. As I mentioned, I'm the Vancouver managing partner. Since it's a law firm, we are setting out a disclaimer that this is not intended to operate as legal advice. If you have particular concerns relevant to your situation, please seek out a qualified professional to get that advice. This is for informational purposes only. Next slide, please. Dave Pentland. I'm lucky to be joined by Dave. He's a senior customs officer, customs broker, I should say, and I've worked with Dave on many matters for many years. And Dave and the Carson International team know what they're doing when it comes to customs. They have deep and broad experience with valuation issues and customs compliance issues. Dave, you want to say something about Carson and yourself?
Yeah, good morning, Dan, good morning and good afternoon if you're situated in Eastern Canada. My name's Dave Pentland. I'm a Senior Vice President with Carson International. My matters of expertise are customs compliance and client services. Carson is a logistics provider and licensed customs broker both in Canada and the United States. And we have offices across Canada, and I've been at this personally for 40 plus years since we opened in Vancouver, April 1st of 1983, and the company's been around just over a little bit more than 10 years beyond that. So pleased to join Dan anytime on matters like this. As Dan indicated, this is probably one of the biggest, most contentious valuation topics that CBSA has proposed, certainly since I've been a licensed customs broker. So back to you, Dan.
Thanks. So I'm licensed to practice law in Canada and the United States, 30 years of global trade and customs experience, and lead the global trade and customs group at Miller Thomson. We have substantial experience with dealing with valuation matters, both on a planning standpoint, and every year there's a fresh crop of audits that deal with valuation issues, and we deal with the fallout from those, sorting out and appealing from assessments and dealing with verifications and appeals. Next slide, please. So, we set out a little quote here: money is not the value for which goods are exchanged, but the value by which they are exchanged. Money represents a system or a medium for facilitating an exchange. And this seemed to fit this topic, because our topic for today is how should importers value goods from a monetary standpoint. Next slide, please. So, just to give you a high overview of why we're dealing with proposed changes to the customs value for duty regulations. They've been in place for many, many years. There's a body of case law that deals with interpretations of provisions of the Customs Act and the regulations. So why change now? Well, the government has set out a regulatory impact analysis statement. It's dated May the 27th of this year. And they set out a few items or rationales that speak to this. They say that there's been a huge increase in global trade methods, especially e-commerce trends have expanded. Non-resident importers with minimal operations and investments in Canada have assumed a growing share of imports. The Customs Act and the Valuation for Duty regulations, they say, do not align with the World Customs Organization regarding interpretations of the meaning of sale and the last sale rule, which we'll get to in a minute. And the Canadian rules involve a narrow interpretation of sale, which focuses on when the transfer of title occurs and a purchaser in Canada definition, which we'll also talk about, allowing an importer with a permanent establishment to use a sale, the supply price between a foreign company and its Canadian affiliate, for example, as the basis for valuing the duty of goods. So in a nutshell, they're saying that in Canada, you can generally use a lower value where it is more appropriate to use the last sale and a higher customs value for duty purposes. They also indicate that the World Customs Organization rules indicate that sales should be interpreted in the widest possible sense, applying the last sale in the country of import and not the earlier sale between entities. So there is in the parlance of the government a misalignment, an unfair advantage. Non-resident importers can use an earlier sale to supply costs rather than the cost to Canadian customers as the basis for the value for duty of goods. And so the government is wanting to capture additional duty and require importers, especially non-resident importers, to adjust upwards their value for duty appraisals. David, any comments on this?
Yeah, I mean, as we work our way through some of these scenarios and some of the proposed changes, my personal comments are, this looks as if it's intended to target offshore e-commerce sites that are fulfilling goods in Canada, and also non-resident importers that have done a lot of studying on their supply chains and costs. And I think the CBSA, I don't want to slam them too hard, but I think their intention is right through the government looking at this. However, I think they're rushing into it without a little bit more due diligence. So as we get through the presentation, you'll see at the very end of the slide, I'm going to emphasize it now as I will at the end of the slide. We're still in the comment period, and this comment period was supposed to expire on June 26th. There's been so many comments so far that they just extended it 2 days ago to July 26th. So what we're telling you about right now are proposed amendments, and it's as you listen to the rest of the presentation, take note of the very last slide, because there's many people and groups and entities that comment with what they believe will be impacts on their organizations. The government's listening. So my 2 bits were.
Okay, so on to the next slide, please. This set of rules impacts the way that the transaction value method will be applied. At present, the Customs Act identifies 3 requirements that must be met in order to use the transaction value method when appraising goods for duty purposes. The item has to be, or the good has to be sold for export to a purchaser in Canada, and the price paid or payable can be determined. The transaction value method applies if all the elements have been met. And somebody just in the chat indicated that they'd like to see a copy of the slides. Yes, we'd be happy to send you a copy of the slides afterwards. So don't worry about having to jot down notes so that we can make this slide deck available to you. On to the next slide, please. So the term sold for export to Canada is undefined in the legislation. And so the courts have provided more meat to the bones, has provided an interpretation of what the meaning of sale for export means. And the Mattel case stands for the proposition that for the purpose of determining the transaction value of goods, the sale for export to Canada is a sale by which title passes to the importer. And that has been a key customs rule for over 2 decades. Next slide, please. There is additional case law, including the Ferragamo case, which dealt with the meaning of the other element that's in play here, which is purchaser in Canada. And remember, you have to have a sale for export to a purchaser in Canada to meet the transaction value methodology. So it confirmed that a purchaser in Canada includes a business with a permanent establishment in Canada. And a permanent establishment is basically a fixed place of business through which a person can carry on business with one or more employees working at that fixed place of business. So the outcome of all these regulations is that businesses have been setting up permanent establishments, a fixed place of business through which they can carry on business in order to minimize duties. And a typical setup of a fixed place of business is with one or more employees. They take orders from Canadian customers, that's considered a domestic sale, order goods from a foreign supplier, and then declare the foreign supply costs under the transaction value method. And so they can use that methodology in this modus operandi to declare the foreign supply cost, not the higher Canadian customer cost. That we see will change under the proposed legislation, and it will cost more money to import goods into the country if you're a non-resident importer, unless you maybe avail yourself of one option, or maybe there's others, but you have to kind of analyze this. So the proposed changes will impact the duty minimization model, and they will require the declaration of the last sale. And we will take you through a few scenarios, but the thrust of the proposed legislation is to capture the last sale, which will often be the Canadian customer cost rather than the lower foreign supplier cost. Next slide, please. So there's a few pieces of legislation that will be amended. Section 2.01 sub 1 will define the meaning of sold for export to Canada, and it will mean in respect of goods to be subject to an agreement, an understanding, or other arrangement, regardless of form, right? So an agreement, an understanding, an arrangement, regardless of form, to be transferred in exchange for payment for the purpose of being exported to Canada. So in respect of goods, in relation to an agreement, basically of any form, for the transfer of goods in exchange for payment for the purpose of being exported to Canada, regardless of whether the transfer of ownership is completed before or after the goods are imported. So what does that all mean? Basically, we aren't going to be worried about when title passes anymore, right? The current state of the law is the Mattel case, and you concern yourself about whether or not a person has title, because the person who has title at the time of that goods are brought into the country is considered the importer. No longer are we going to be worried about that. What we're going to be worried about is whether or not there was an agreement for sale, and it's going to be interpreted in the widest possible sense. So that's how the government is going to capture the higher valuation. That's how they're going to say that the Canadian customer cost, the price paid or payable by the Canadian customer, is the value for duty, the value that has to be declared for duty purposes. So if sub 2 indicates that if the goods are the subject of 2 or more agreements, understandings, or arrangements, it is the one respecting the last transfer of goods in the supply chain that counts. That's the one that counts, the last one in the supply chain. So the impact is that if goods are subject to an agreement to sell to a Canadian customer, and a business with a permanent establishment takes the order, buys from a foreign supplier to fill the order, the value for duty will likely be the Canadian customer cost, not the foreign supplier cost. And that could add quite a substantial amount of duty costs to the business model. David, any comments?
Yeah, I mean, the two main comments are, one, CBSA and CITT have really disliked the Supreme Court's Mattel ruling from 2001, which set the landscape that non-resident importers and other companies that were related companies were able to structure their arrangements to pay the lowest duty possible. And it's almost as if they're changing the rules of the game because they didn't like how the game was being played. And they're going to set aside that decision because the rules will change if this goes ahead as proposed. And like Dan's mentioned, the last sale will become the value for duty, which to me is, there's all sorts of issues. Second comment is, hopefully this legislation will not be passed quickly because unfortunately our government sometimes forgets that companies are planning 6 months to a year and a half out on relationships and buying agreements and things like that. So that should be part of the comments from the trade, is that certainly don't close the comment period and make this effective, a month later, because it would very, very difficult and put a lot of hardships on everybody importing goods into Canada. So.
Yeah, 100%. I think that it's that's an important point, that it's taken a while for business to adjust to the current state of play and the rules, and it would take some period of adjustment to deal with any proposed legislation. So there should be a bit of runway given to the industry in order to cope with any changes. Next slide, please. So again, another piece of legislation that we refer to, Section 2.1, which basically will define the term purchaser in Canada, which will mean in respect of goods that will be the subject of an arrangement, an understanding, or an agreement, the person who, under that agreement, understanding, or arrangement, who purchases or will purchase the goods, regardless of whether or not the person is the importer or whether the person makes payments in respect of the goods. So it's future looking, like who's going to be the person who's going to buy the goods, where do they fit in the supply chain. If they're at the last end of the supply chain, that's where the customs verification officer will likely look in order to appraise the value for duty of goods. So it's a different approach entirely to the existing regulations. David?
Yeah, to me, this is putting more emphasis than in the past. Historically, customs would focus on purchase orders and look through how the purchase order matches up to sales price and sales agreement. This is almost as if they're looking at you, the importer, who are you selling to, and starting there and going backwards. And to me, every time they use the word regardless, it scares me because it's opening the interpretation to the CBSA officers to interpret who you're selling to and is that the last sale. And so to me, it's a slippery slope that's is worrisome. So we'll have to just wait and see how it happens. But again, we're in comment period, so please express your comments to our government.
Yeah, so I noticed there's a few items in the chat, and I'm not ignoring you. I think what we'd like to do, in the best of all possible worlds, is to answer these questions after our session, because some of them are detailed and they need a little bit of noodling through. And we're still in the regulatory impact analysis commentary stage. So we, things are a bit in flux. So that's what I'd like to do. The next slide, what is the gist of all this? I just wanted to underscore a few points. Ensuring that sale is interpreted in the broadest possible sense. That's one of the objectives of this proposed legislation. Ensuring that the last sale in the supply chain is the one that's going to be considered the relevant sale that counts for customs valuation purposes, and delinking the concept of sale for export from the transfer of title. We're no longer going to be worried about who has title to the goods. We're going to be looking, for example, to who will purchase the goods in the future, and then fitting that person within the supply chain. Next slide, please. Objectives, again, the regulations, the proposed regulations will clarify that any form of intent to sell or purchase will count as a sale for export. So, if you're intending to import inventory and you do things like, you get a draft sales order or something like that, you might run into trouble. So you have to think about how you're importing on speculation of sale and doing forecasting and so forth to make sure you fit within that regime and not get captured by the proposed legislation, because sale is going to be interpreted in the widest possible sense. Who will buy these goods, right? And so if there's a blanket order form, that's going to be reviewed by the verification officer, likely. For example, objectives for amending the term, again, it indicates that importations on speculation of sale are an option, right? So at the end of this, you may think, if we can't use our current business model, say we have a permanent establishment, we want to order goods from a Canadian customer and then purchase them from a foreign supplier and import them, we're going to end up having to pay a higher duty amount. Maybe one of the options is we'll import goods on speculation of sale and as inventory. And then, arguably, you may have an arguable position that the goods should be valued on the basis of their foreign supply costs, because there's no person that will buy them in Canada when they're brought into the country. And there's no overarching agreement. So that's the kind of strategy that may enter the mix going forward.
And
Next slide. Go ahead, David.
Yeah, just one comment on that. Specific industries have unique buying arrangements, and I'm just we do a lot of garment importers, and the garment importers want to get a sense for what the market will purchase without tying their customers to a binding agreement. So historically, people would have their reps go out. They would actually take booking orders. And a booking order is really not a binding agreement in any way. It's just an indication that they intend to buy that if they have a good season, if the cash is available, et cetera, et cetera. And in those cases, it enables them to go to a foreign manufacturer and say, I think I can buy this amount, and I'm going to hedge my bets and buy 25% more. So there is no sale that's taking place. That's going to dismiss a lot of those, because the government's going to look at blanket purchase orders or booking as that is now somewhat of a sales agreement, that your indication to buy the goods, and that's not the case. And so those bookings, people walk away from them, they cancel them, they double them, and it's industry specific, and I think that's at jeopardy by the wording in this proposed legislation. And our government hasn't really looked at that, and I think it's a way to disrupt entire industries. And so again, it's it's time to make those comments felt because, Canada, we will lag behind other countries, and the cost of goods, I think, will rise because of this legislation. So.
Yeah, one of the most hotly contested issues will probably be whether or not the goods were the subject of an agreement, understanding, or an arrangement. What are the meanings of those words, right? And so going forward, there'll probably be cases that will interpret the meaning of that language. So again, objectives for amending the provisions. It removes a linkage between the definition of purchaser in Canada and the concepts of residency or permanent establishment. They're no longer really that important. A purchaser in Canada is a person who has or will purchase goods in a sale for export to Canada under an agreement, an arrangement, or an understanding. And it's designed to ensure that the value for duty of goods under the transaction value method are based on the last sale in the supply chain. So we have a couple of scenarios that will give you examples. And thanks to Dave and Satinder Baines for putting together these slides. So we see, first of all, proposed amendments scenario 1. Not too tricky. Company A purchases from company B, and then company B buys from company C, and there's a delivery. So company A in Canada buys goods from company B outside of Canada, and company C, the supplier, drop ships them in Canada. Sale 2, being from B to A, is the last sale in the supply chain that causes the goods to be exported. So likely sale 2 would be considered the relevant sale, right? You get there the idea that the last sale in the supply chain will be considered the relevant sale for valuation purposes. David, any comments?
No, other than don't try and copy down or quickly drop these descriptions. They're available on the proposed regulations the government put out, along with 4 other ones that seem to be somewhat muddled. We put the 4 most pertinent ones here. The next slide actually has the verbiage that goes along with the slide. And again, you'll get copies of that if anybody would like them. So, yeah.
We won't bore you with the details of the explanation in this next slide. We'll just move on to slide with scenario number 2. So here, again, a typical scenario. It looks like it's based upon, a case that might be cherry sticks or something like that. In this scenario, company J in Canada enters into a blanket purchase agreement with foreign company K. K orders the goods from company L. Company L delivers them to a warehouse in Canada. And I guess into this scenario, the goods could be made available for inspection by J. J decides whether or not to accept delivery. The blanket agreement is between J and K is the relevant sale for export. The rule in cherry sticks is altered by these proposed changes because cherry sticks would suggest that you could use the foreign supply price as the basis for the valuation for duty, but no longer. Under the proposed amendments, you would use company J's purchase price as the relevant sale. David?
Yeah, this is very common practice right now where title and transfer of goods. And as you saw in the previous slides, that's going to be put aside. And so the relevant sale in this case would be from company K to J, ignoring company L and shipping to a third-party warehouse. And the risk is on company J. That would have no bearing on the valuation. It would be the value between company J and K. So,
yeah. Shall we go to scenario 3? So scenario 3 it looks like a little twist. The relevant sale here is between company O to the customer. In this situation, in this scenario, the Canadian customer orders goods online via foreign company P's website. The website is set up for company P's affiliate, company O, a Canadian company, and then two invoices are generated. There's a flash sale, I guess you could put it. One from P to O and the other from O to the customer. So the company fills the order and drop ships the goods to the customer, one from P to O and one from O to the customer. And the last sale, this is the important part, is in the supply chain is the sale to the Canadian customer. So they capture the highest possible value for duty purposes. So a lot in there, but basically the notion here is that we're not worried about title. We're worried about where the last sale is in the supply chain, and we're looking to the last sale under an arrangement which causes the sale for export to Canada. David?
Yeah, this is one that I think the government needs to go back and look at. Sometimes what you wish for is not, in fact, what's going to take place. Is that in this case the consumer is the one that they're determining caused the sequence of events, and therefore it should be the price the consumer paid is the value for duty. Right now in the scenario, company O is located in Canada, often a distribution company. It may open the door for a little e-commerce company called Alibaba to take a look at this and say, well, we'll just bypass and ship everything out of our DC in China directly to consumer if that's the valuation process. And so are they really looking at jobs and warehousing in Canada? And they may get something entirely different from what they're looking for. So my comments only. So.
Yeah. Scenario 4, please. A little bit more complex supply chain, 3 sales to be considered. The relevant sale is sale 3 between company T and its sales agent for company U. In this scenario, the Canadian company U is an affiliate of foreign company V. Sales by U are achieved by way of sales agents, and the sales agents makes a sale to the Canadian company. So in terms of the explanation, an order is placed through company V's computer system, a back office service provider for U. 2 invoices are created, one from U to T, another from V to U. There are 3 sales from company W to V, from V to U, and from U to T. The goods are shipped by W to T. All sales are considered to have occurred prior to the importation of the goods. The sale 3, the third sale, is the relevant sale from U to T. So they're going to capture, or the proposed regulations are intended to capture that particular sale from U to T. David?
Yeah, this may look like a convoluted diagram of the transaction, but many related companies have set up their transfer pricing agreements and spent a lot of time, money, and energy based on Canadian laws that have enabled them to take advantage of it. And so, going back and using CBSA's words on decoupling, they're going to throw a lot of this out the window, because now you're going to have the transfer pricing will play no part in it, and it'll be the sales agreement between company T and company U, and where they've had transfer pricing agreements between company T and W when those companies are related. So it just opens a lot of question marks. for related firms selling around the world. Not, so their transfer pricing agreements will hold up in many other countries, and they're going to have to revisit what that agreement looks like under the proposed scenario in Canada. So.
Okay, so next slide, please. Our takeaways here, the proposed amendments are intended to result in higher appraisals for the valuation for duty of goods. The government of Canada considers the current regime to be suboptimal insofar as they see there being some slippage in the amount of customs duty that they could otherwise capture and levy on goods. And these proposed regulations are designed to do that. The converse or flip side of that is that importers will bear the burden of that, and the ultimate customer will probably bear the burden on that if the costs are passed through to the ultimate customer. So somebody's going to have to pay for this, and it will impact businesses insofar as they will need to or should evaluate their current state, consider their future state, and decide whether or not it's necessary to adjust the current business model to take into account the regulations and the likelihood that there'll be increased duty costs if the business model isn't changed. So that's where I think the rubber hits the road. We're in the regulatory consultation phase. There is an opportunity to provide representations to the government of Canada and to make a pitch as to whether or not this is a good idea or whether or not it is not a good idea to enact the proposed regulations. If it looks like it's going ahead, it's probably a good idea to do a gap analysis, an analysis to deal with the gap between the current state and the future state and what your options are. I see one of the options being moving, if you're able to, from an order-based model to possibly a model that is focused on the importation of inventory, unsold inventory into Canada on speculation of sale. That may be a possible way of continuing to minimize duties levied on imported goods. David?
Yeah, I guess it's worth noting that I think the government, hopefully they've looked at the negative impacts on taxes and income, and that it's just not an offsetting, that the increased duties are going to offset the increased amount of revenue they would have made off people paying taxes on profits in Canada. But I'm going to defer. Hopefully our Canadian government's already looked at that. The other thing worth noting is that the United States, our biggest trading partner, has a very lucrative first sale rule, which flies in the face of this totally, where if you're in the United States and somebody in Canada wants to buy something at a I'm going to use just $100 value and from China, and you already have the sale in the United States, and that sale is $200, you can actually import those goods at $100 if it's going into the United States. So this flies in the face of that. And again, they're our largest trading partners. So I hope our government's looking at that. Certainly, we pointed it out. I sit on a boards of a few bodies that's been pointed out to CBSAs already. And also on the e-commerce side, this is really, is it really? I'm not totally convinced right now that they're trying to make it to mirror what the WCO is doing with e-commerce. But again, I think the next slide we go to is the last slide we have. Is going to, give you some options what to do going forward. So.
Next slide, please. So here we have it. Importers have until July the 26th 2023 to make their submissions to the CVSA. They can be provided on this link. Dave has a lot of experience dealing with these types of submissions. I know our firm has also been asked to make submissions on behalf of some of our clients. It also is probably useful to work through your industry associations, such as they are, to make sure that if you can have a unified voice, that you have one.
Yeah.
So
Yeah.
that's where we're at, I think. You going back to what you were saying earlier, David, I think you're bang on. You take a look at Canada and the US, it's almost like we're in a study of opposites. Canada's moving to the last sale to capture the last sale and the highest value, and the US is looking at the first sale, right? And it's using the first sale. So it's quite interesting to see the different approaches.
Yeah. And just to further Dan's comments before we wrap it up is that singular voices are great, and I would say don't just leave it up to your industry associations, but certainly use them, because when you have a united body, the government looks at that as a group, but at the same time send it in from your company specifically as well. So I think the government needs to kind of put a pause button, press the pause button on this, and kind of rethink it, and maybe tighten up some of that language. I hate the language of decoupling regardless. Usually everything we deal with customs is fact-based, based on court cases. This purposely looks as if they want to take it from black and white, and they want to control the gray dialogue, and that scares me. So.
All right, so a lot of good questions. We'd be happy to answer your questions after this thing. I think we've run out of time trying to answer questions, and for the other reasons I mentioned, very technical and complicated, and I think we'd be better off having one-on-one responses. So if you have questions, please send them to Dave, myself. We'd be happy to be in touch with you and discuss, what our take is on the proposed legislation and how it might impact you. We would be very grateful if you would send out or stay on and fill out, I should say, a little survey that we have. We want to provide content that is useful, and so we would really appreciate it if you would provide your comments. And we also send out the slides. Gus and his team, our marketing folks, can do that, or I can do that if you send me an email. I'll send you a copy of the slide deck. So with that, I would like to say thanks for attending. I really appreciate it. It was nice to have a conversation with you, Dave. I always enjoy your take on things. And I wish folks you a great day.
Yeah, thanks again, Dan.